Hi everyone. I'm coming up with this new series on law of evidence, and this would be comprising of around 15 to 16 lectures. And in this would be a very comprehensive series in which we will discuss law of evidence from both preliminary as well as mains point of view. Starting with, as we all know, that law of evidence in Indian context is determined by Indian Evidence Act of 1872. This subject is important from the perspective of judicial services, for the assistant prosecution officer examinations of different states, as well as for general understanding of the procedural law. And this law of evidence is applicable on both the civil proceedings as well as the criminal proceedings. So starting with the first lecture of law of evidence, we will discuss about different topics in different lectures. In this lecture, I am going to discuss about the interpretation clause, and we will touch a bit on the relevancy and admissibility aspect as well. The enforcement date of this Act of Indian Evidence Act is 15th September 1872, and the enactment date is 1st of September 1872. This act is known as lex fori, or we can say that the nature of this act is of lex fori, that is the rule of the place of trial. And most important thing is we have to keep in mind is that law of evidence is not of comprehensive nature. The reason being, section 1, which talks about the short title, commencement and extent of this act, it gives with certain exceptions. It actually provides us with certain exceptions on which Evidence Act would not be applicable. And there are other laws as well, such as Bankers Evidence Act and so on, which basically provide a procedure a procedure of collecting evidence which is different from this act. So we cannot actually determine, or we cannot actually say that law of evidence is of a comprehensive nature. Moreover, the preamble of this act, it actually tries to consolidate, define and amend law of evidence. These points are important from preliminary point of view, because usually the enactment date, the enforcement dates and what the preamble states is being asked. Lex fori, you have to know the nature of any law before going into the intricacies of that law. So what I did for remembering this, the preamble, the purpose of the preamble was, I used to see, you all have heard about PDA. So this is just a trick of remembering the preamble, what it provides. Like it provides for CDA. C stands for consolidation, D stands for definition and A for amendment. So it basically provides us with three things: consolidation, definition and amendment of law of evidence. You have to keep in mind these three things, because usually the question which is being asked from the preamble is what it does not provides. So you four options would be given, out of which one would not be provided in the preamble. Moving on to the next slide. Now, for every lecture which I will be coming up with on law of evidence, I will give you a synopsis in the beginning about how we are going to continue this lecture. Starting with the synopsis of this lecture, we are going to discuss about, as I told you in the initial point itself, on the initial point itself, that we are going to start with the interpretation clause. So interpretation clause includes certain definitions of court, of evidence, of fact, of some definitions like proved, not proved, disproved, and all these such definitions are important from both preliminary as well as mains perspective. Here I am going to discuss about the fact, what actually fact means, what is included in fact, what is relevant fact, what is fact in issue, what is the difference between the two. Then we will move on towards interpretation of evidence. evidence is specifically not defined under Evidence Act. It provides us with the different forms or the methods in which evidence can be given. Like it can be oral, it can be documentary, it can be a direct evidence, it can be a circumstantial evidence. We will move on with the lecture. I will explain you each and everything, what is direct evidence, what is circumstantial evidence, what is the relevancy of these evidence, and how and why these kinds of evidence are important. Now evidence can be categorized further into different heads like primary and secondary evidence, which we will be discussing in the upcoming lectures, oral and documentary evidence, presumptive evidence, original and hearsay evidence. Presumptive evidence also, there will be a separate lecture on presumptive evidence. There are certain presumptions which the court makes. Usually the procedure or the proceedings move on the basis that who has this the liability to prove or the burden of proving, but there are certain cases in which the burden of proof shifts because of the presumption which the court actually takes at the initial stage itself on the fulfillment of certain circumstances or on the fulfillment of certain conditions. Starting stages of trial and evidence. So basically there are two kinds of cases, civil case and criminal case. Law of evidence deals with both the kind of proceedings. First we'll deal with the civil case proceeding. So it starts by filing of suit by the plaintiff, under which after the filing of the suit summons are issued to the defendant. Then the court has this duty of striking the issues which are to be decided and settled as a result of the trial. So then the next stage which takes place is of actual trial of the issues. Evidence is given by the parties to prove or disprove the issues. Court finally pronounces its opinion after weighing the evidence brought before it, and the opinion of the court is known as the judgment. The enforcement of this judgment is known as execution of decree. Then comes upon, we'll discuss the proceedings or stages of trial in the case of criminal proceeding. Prosecution is started by the prosecutor or the complainant is filed by the private person in the court. Summons or warrant are issued on basis of the kind of case which is to be dealt with or the kind of case of which the complaint is made. Then the court frames the charges on the basis of which either the accused pleads guilty or he pleads for the trial. If he pleads for the trial, then the evidence of the prosecution is taken, and along with it if the court feels or the court thinks that there is a chance of the or the prima facie it appears to the court that the offense must have been committed, in that case the evidence of the defense as well is taken on record. Finally, the court pronounces its opinion after weighing the evidence brought before it, and this opinion of the court is known as the judgment. The enforcement of this judgment results in acquittal of the accused or sentencing the accused, that is the conviction. So, evidence is basically weighed after the framing of issues, and in the case of a civil case, and after the framing of charges by the court, and evidence is given by both the sides, the plaintiff and the defendant in case of civil case, and here the prosecution and the defense in case of a criminal case. What is the value of the evidence which is given by the parties to the court? It depends upon case to case basis and how the court actually how it is presented before the court. So moving on to the next slide. Section 3. Now we are going to start with the interpretation clause. Before dealing with the fact, the relevant fact, evidence, we should first understand what is court, because it is the court before whom the evidence would be actually given, rendered, and it is the court which decides whether a particular evidence is admissible or not. Starting with the definition of court, which has been provided under section 3 itself, it includes all judges and magistrates and all persons who are legally authorized to take evidence. There is one exception which has been provided under this definition, and as we all know, with the general rule, you have to keep in mind the exceptions as well. So one exception which has been provided is of arbitrators. Jagadguru Anand Nishwara Mahaswamiji versus VC Alipur is a case of 2009 Supreme Court judgment. What it stated was that the court includes a tribunal whose decision is final and who is authorized to take evidence. Now, what is important over here is authorization to take evidence, because if evidence act is not applicable on a particular on a particular body, it would not be considered as a court. If it does not has the power to take evidence, it shall not be considered as a court as per the Indian Evidence Act of 1872. Brijnandan Sinha versus Jyoti Narayan 1956 decision of Supreme Court. It stated that any tribunal or authority whose decision is final and binding between the parties is a court. In view of this, court further held that a court of inquiry is not a court. Why a court of inquiry is not a court? Reason being that this court does not have the power to take evidence. Now this question was actually important from only preliminary point of view, because what you needed to remember here was that what is not included in the code. But in 2018 UP Judicial Services mains examination, there was a question that what is code, and you have to you have to write the answers with decided cases, with the help of decided cases. So I think this would be sufficient. Further, you can actually elaborate this by giving it in points. So moving forward with the important aspect of this lecture, fact and relevant fact. What is a fact and what is a relevant fact? Or what is fact in issue? First, fact, it means and includes, it has been defined under the Section 3, the interpretation clause. It is an inclusive definition. It includes anything, any state of things, relation of things capable of being perceived by senses, relation of things which are capable of being perceived by senses, or any mental condition of which a person is conscious. So here what all is included is physical fact as well as psychological fact. Explaining it with an example. Now, example is like there is a fact that A shoots B. Now, this is a physical fact, that whether A shooted B or whether B was shooted by A, whether A had that gun in his hands at the time of the death of B, or whether they were in physical presence of each other, that there is a probability that A might have shooted B. All these are physical facts. These are capable of being perceived by senses. I can actually see A shooting B, or you can hear A shooting B. These things are actually which can be perceived by your senses. Another thing is whether A had that intention of shooting B. Now, if A had this intention of shooting B, that would be considered as a psychological fact. So, Indian Evidence Act, it includes both kinds of facts, physical fact as well as psychological fact. Fact in issue and relevant fact is the next important aspect or important definition which has been given under the interpretation clause. You need to remember the difference between the two. This is important from both preliminary as well as mains examination. Usually the difference is asked between fact in issue and the relevant fact, or an example is given that whether this would be a fact in issue or a relevant fact. First of all, under the Evidence Act, there is no list of fact in issue which has been provided, while a list of relevant facts has been provided from section 5 to section 55. The chapter itself states of relevant facts. So there is a list which has been provided which comprises of different relevant facts which will be taken into consideration. As we will move forward with the lectures, we will discuss about different relevant facts. For the time being, first we need to understand what is the difference between fact and issue and the relevant fact. Fact and issue is known as factum probundium or the principal fact. I will actually not go in the form of that of difference. I will first explain fact and issue, then we will move forward to relevant fact. Meanwhile, I'll keep on actually highlighting the differences between the two. Firstly, we will discuss about the fact and issue. So, factum probundium or the principal fact. These legal maxims, they actually act as a bonus point. Whenever you write an answer with a legal term, with a Latin terminology, it basically highlights your understanding as well as your capability of remembering the basic uh, terms or the basic maxims which you were taught at the time of the entrance examinations, at the time of LLB entrance examinations, like CLAT or the examinations which take place at different levels. So, fact and issue is known as factum probundium or the principal fact. It is the fact which actually needs to be proved, which is on basis of which the whole case rests upon. It is the fact which itself or in connection with other fact either determines the existence, non-existence, nature or extent of all these three: right, liability and disability. On the basis on the basis of such fact which actually which actually determines or which actually highlights these four aspects of right, liability and disability, on basis of which, on basis of whom they are actually asserted or denied, such fact is known as fact in issue. Facts on which the rights and liabilities of the parties are based. These are the facts on which the judgment is based. These are the facts which are denied by one party and are asserted by the other. So basically what needs to be determined in the case is fact in issue. Relevant fact is the fact which actually makes the existence or non-existence of fact and issue highly probable or improbable. That's why they are relevant. Relevant actually means important. So why a particular fact is important? Because it is connected with the fact and issue. It will either make its existence highly probable, that this must have happened, or it will make it no, it can't happen, this is something which is not actually possible to happen. So these facts are relevant. Like here I will take an example of alibi. As you might have heard, there is this defense of alibi which sometimes the defense counsel takes place. Alibi basically implies that a person cannot commit a crime because he was physically not present at that place. For example, a murder was committed at Lahore, and a person named A is being accused that it is being considered that he might have committed this crime. Now A can actually prove this fact by his presence in Kolkata at that point of time, by the like he might be in government office. So there is a record or register kept in government office that whether he was present at that time in or on that date at Calcutta or not. So if he proves that he was not present at Lahore where the murder took place, that in that case it is highly improbable that he might have committed that murder. So this is how this plea of alibi is actually taken. Now this makes it a relevant fact. So moving forward, it one thing more, relevant fact is known as factum probuntia. So this is factum probundium, this is factum probuntia. This is the fact on basis of which the whole case is dependent. This is the fact which makes the fact and issue either probable or improbable. This is of indirect nature. It does not affect the case directly, rather it affects the fact in issue on the basis of which the case is based upon. Such facts have probative value because these are the facts on basis which actually makes the existence, which actually questions the existence of fact in issue. These are the facts which are advanced to prove the existence or non-existence of fact in issue. As I told you in the initial, before beginning with the difference itself, that sections 5 to 55 provides us with a list of relevant facts. Moving forward with the next aspect, that is evidence. Now, as I told you in the initial minutes itself, that evidence is not defined under Indian Evidence Act. It basically provides what all should or what all can be included in the evidence. So it includes all statements which the court permits or requires to be made before it by the witnesses, or in relation to the matters of fact in under inquiry. And it also includes all the documents, including the electronic records which are produced before the court for inspection of the court. See, I will be discussing the exact bare provision. So evidence includes the instruments by which relevant facts are brought before the court. There are two categories which in which the evidence has been interpreted under the Indian Evidence Act, under the interpretation clause of Indian Evidence Act. One is the oral and other is the documentary. As you can see, that the first one states about the oral evidence and secondly states about the documentary evidence. So oral evidence, it can be further categorized into two. First is the direct oral evidence, other is the hearsay. So the general rule is that the direct evidence must be brought before the court and not the hearsay evidence. While another category, that is the documentary evidence, comprises of primary and secondary evidence. Here also the general rule is that the primary evidence must be brought before the court, and there are certain circumstances which have been defined or which have been given. Those conditions have been provided under section 65, under which only the secondary evidence can be brought before the court. Moving on to the direct and the circumstantial evidence. Now, this is the place from where main question arises regarding the circumstantial evidence. See, direct evidence is the evidence about the real point in controversy, while it deals with the matters which are perceived or which can be perceived by the senses. While the circumstantial evidence, it is the evidence of the circumstances. It relates to the other facts than the fact in issue. But by experience, it is associated so closely with fact in issue that it has this relation of cause and effect with the fact in issue. That's why the circumstantial evidence is relevant. It is important. There are certain decisions of Supreme Court in which the relevancy of the circumstantial evidence was considered, whether a circumstantial evidence and under what circumstances such evidence shall be considered as important, as relevant, has been defined or have been discussed under certain cases, starting with C. Chenga Reddy versus State of Andhra Pradesh 1996. It actually provided the nature of the circumstances in from which the guilt or which can be from which the guilt can be drawn or which can be given before the court in evidence. Such circumstances from which the guilt is drawn must be fully proved. Such circumstances must be of conclusive nature. They must be complete and no gap must be left in those circumstances. They actually should tell you a story, and everything should go in a flow in that story. Now, if there is any gap which we can find in that story which is very abrupt, in that case such circumstances would not be considered as relevant and they would not be taken into consideration as the evidence. Such proved circumstances must be consistent only with hypothesis of the guilt of the accused. There are two cases in which the circumstances from which guilt is drawn. Actually, three cases which are important, but the most important one is Sharad Birdich and Sharda versus State of Maharashtra. This is a case which is asked in preliminary examination. It is famously known as the punch shield case. Why the punch shield? Because as the name suggests, it provides us with the 5 principles of the circumstance of 5 principles under which the circumstances shall be considered important, or the circumstances can be taken into consideration as being relevant. There are 4 principles which were laid down in RP Mittal case, and the 5th one was given in this. So first we'll discuss the 4 principles. State of UP versus RP Mittal. Circumstances from which the guilt is drawn in first instance must be fully established. Such facts must be consistent with the guilt hypothesis. Such circumstances must be conclusive, and they must exclude every other hypothesis. The 5th one being, the chain of evidence should be complete. It should not leave any reasonable ground for conclusion of the innocence of the accused. That is, it must in all human probability, it must highlight, it must direct that the act was done by the accused. So here are the 3 cases which are important from point of view of circumstantial evidence. This one being the leading case, the most important case which everyone must keep in mind for actually discussing about circumstantial evidence. There are certain other definitions which are important under the interpretation clause, and these are important from point of view of preliminary examination as well as from the aspect of the interview. So there are certain facts which are proved, which are disproved, and which are not proved. These are the terminologies which are being generally used by the court. First is proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under circumstances of particular case, to act upon the supposition that it exists. So what we are taking as proof, that is something which court believes to be existing, or a prudent man would believe to be existing. Disproved would be something which the court believes that it does not exist or considers its non-existence so probable that a prudent man ought, under all the circumstances under which the court is considering, would act under this supposition that it does not exist. And not proved is a fact which is neither proved neither disproved. Simple. But these actually become confusing at the point of time when they are asked in the preliminary examination. So one must remember the difference between the proved and the disproved and the not proved. These two become confusing. Moving forward with the next slide, which actually gives you a distinction between relevancy and admissibility. So this is actually a thing which I'm going to introduce in our lecture series, in which we will discuss a bit about the next class or the next lecture, which we would be starting with. So in the next lecture, I would be considering about the relevant facts. I would be starting with the chapter of relevancy. Before moving on the chapter of relevancy, you should understand the difference between relevancy and admissibility. There is this general notion at times that both the expressions are same. What is irrelevant is admissible, and what is admissible is generally only what was irrelevant earlier. But there is a distinction between the two, and this distinction was actually recognized by the Supreme Court way back in 1988 in the case of Ram Bihari Yadav versus State of Bihar. In this case, the Honorable Supreme Court stated that more often than not, these expressions are used as synonyms, but their implication is far different from their implications are different, and we cannot understand that difference until and unless we go through the Evidence Act. So before moving on with the relevancy, you should actually understand what is the basic difference. Their implications are different because more often than not, the facts which are relevant are not admissible, and vice versa. जैसे कि communication made by a spouse, this is a relevant fact but it is not admissible. Similarly, communication between a client and an advocate, it is a relevant fact, but it is also not admissible. There is a reason behind these are the conversations which are considered as privileged communications or privileged conversations. So such kind of communication, it cannot be revealed before the court until and unless there are certain circumstances, like in case of a communication made by a spouse during the marriage, that is the general rule that it should not be considered. Any evidence in favor of such communication shall not be accepted by the court, but it can be accepted on certain grounds, and those grounds have been specified in the section itself. We will go through those grounds when we will be discussing about this section. Similarly, there are certain facts which are admissible, but they may not be relevant. See, as I told you, there is a list of relevant facts which have been provided under section 5 to 55, and apart from that list, there are certain other facts which are admissible, but those facts are not relevant. They are not covered by these sections, like the questions which are permitted to be to be asked in cross examined, or the questions which are usually asked to impeach the credit worthiness of a witness. In such facts are admissible, but they are not relevant. So there is this difference between relevancy and admissibility, and we are going to discuss this in points form now. Like relevant facts are those facts that may be proved, like fact in issue and relevant fact. Admissibility is the method of proving the relevant facts. So relevancy deals with the facts which are relevant, like fact in issue, relevant facts. But admissibility is the method of giving those relevant facts or proving those relevant facts. Like method includes, it can be in a documentary form, it can be in oral form. So we will be discussing about admissibility of facts at the later stage in the later lectures. uh, the relevant facts or the relevancy of a fact is based upon the logic and probability, while admissibility of a fact is not based upon logic. It is based upon the strict rules of law which have been given under the Indian Evidence Act. These are the rules which are described under section 5 to 55. All the relevant facts have been given under these sections, while there is the admissibility, the admissibility part is discussed at the later stage of the Evidence Act. These are the rules which declare what is relevant, while these are the rules which declare whether a relevant fact or relevant evidence is admissible or is to be excluded. Rules of relevancy means relevant evidence. They may not be admissible. Like I gave you an example of communication between an advocate and a client. Similarly, admissibility means and are modes for admissibility of relevant evidence. So here they are the means in which the or the modes in which a relevant evidence can be brought before the court. These are the facts which are relevant. They may not necessarily be admissible, while these are the facts which are admissible and are in general, they are necessarily relevant. The question of relevancy is a question of law. Very important difference. It cannot be given up at any stage. It is the question which can be, it can be asked or it can be raised at any point of trial, while the question of admissibility is a question of procedure and it is capable of being waived by the parties. So this was all regarding the first lecture. We will discuss about different aspects of Indian Evidence Act in the upcoming series. Please do comment how do you like this series, and whether any suggestions which you would like to make. And I think this is sufficient for this. Within this time frame, we have completed about what is fact, what is a relevant fact, what is fact in issue, the difference between the two, what all is included in the definition of court, or what all is interpreted as court as per the Indian Evidence Act, what are the different stages of a civil case and a criminal proceeding, what is the basic difference between relevancy and admissibility. I will be keeping the lectures of this much duration only, about 30 to 40 minutes time period only. I will not be exceeding this limit. and we will try to complete the Indian Evidence Act within 15 lectures. 15 I think would be sufficient. So here we go. Here we have started. All the best for the preparations, and I hope this helps you out. This helps you in clearing the concepts, and this helps you in preparing answers for the examinations, and it basically helps you in the revision process as well. Thank you.